Well, good morning and welcome to Sunday Morning Coffee with Dr. Childress. Today, I'm going to be discussing what to do after a successful licensing board complaint is made. Uh, and my focus here is partly for the parents to understand your rights relative to professional competence and things, but also to address the now adult children of the pathology in the family courts uh, regarding the responsibility of the mental health professionals who were involved in your childhood and involved in the family conflict and their failure to protect you from the family conflict and the nature of the problems in your family. So this started because I received an email from a parent who had successfully filed a board complaint against involved mental health professional. And it was partly, they were attributing that partly to my education efforts on the professional responsibilities of the involved psychologists. And that, just to stop, to say something about that for a second, that doesn't make me happy that there's been a successful board complaint. It makes me happy that the problematic professional is no longer in the family courts, or hopefully is moving away from the family courts. That we don't need participating child abusers or spousal abusers working in the family courts. What doesn't make me happy is that it means that there was destruction in the family. My goal is not to hold the mental health people accountable. My goal is to stop the destruction in the families. So if we've reached the point of a board complaint that's successful, that's problematic. We needed to fix it back then. I don't need to know what the problem is. I need to know I need it fixed. So I don't need to assign blame. I need the children taken care of. So with that though, they sent me an email, that said they were successful in that, and which raised for me the next issue, which is what to do once a licensing board does sanction the professional for some competence issues or for some issues. The next step is to move into malpractice. And the parent in this case may have grounds now for a malpractice lawsuit, given that the board has found ethical violations. And more importantly, or as importantly, more importantly, I would think, is that the now adult child may also have substantial grounds for a malpractice lawsuit for failure in duty to protect them. Um, so, as I was coming up as a psychologist, one of the things I was told about working in the family courts and how dangerous it was is if there's a board complaint filed against you for anything, because everybody's unhappy with no matter what happens in the family court, there's going to be one unhappy person. And we got narcissistic and borderline pathology that's very revengeful and retaliatory. So all the clinical psychologists know if we go work in the family courts, we're going to face board complaints. It's just part of the work over here. And the danger is if the board finds anything wrong in what we did, even if it's not central to the complaint, they find the complaint was about competence, but they find something problematic in our informed consent process, and they correct us or do some sort of sanctions for that. What happens then is the parent or the can then file a malpractice lawsuit, and that now involves my insurance carrier. So for the licensing board complaint, I notify my insurance carrier, I get an attorney, and the attorney helps me navigate the licensing board thing. And that's a hassle. And it can be for years. These board complaints can go on with attorney stuff going back and forth. But my insurance company will cover a certain amount of for a board complaint. And if I'm working in the family courts, my premiums are higher because they have to do that. Now, when there's a licensing board sanctions, though, you get the sanctions. Now, when it goes into the malpractice lawsuit, The insurance company is going to want to settle that out because they're going to look at, there's already sanctions from the licensing board. And the issue with attorneys and legal things is settlement. All the attorneys, all the legal people like settlements rather than litigation. And what the malpractice insurance company is going to look at is it's going to cost them all this money in the litigation for the attorney time. And they're still going to probably have to pay out something because, look, there's a licensing board and it says ethical violations. And so they'll get out their little charts and do their numbers and come up with potential settlement. Now, for the malpractice damages kind of thing, attorneys always say we can't monetize the damages, and that's probably true. And I'm a psychologist, not an attorney. So you'll have to talk with attorneys about the legal stuff but from a psychologist point of view, it was ethical violations led to misdiagnosis and negligent misdiagnosis and failure of duty to protect. So that's in the scope of psychology malpractice. Whether what the issues are in the legal system is another domain. The other feature, though, to recognize for you parents, if you start bringing malpractice lawsuits, that's going to change the field automatically because they're going to start doing risk management, it's called. And so they're going to start taking actions to reduce their risk. And if their risk is incompetence, well, they'll start becoming competent. So there's value to asserting your rights under the ethics code, your rights, legal rights for competence and things, not only for your matter, but for lots of matters. Part of the issue is licensing board complaints are free to the consumer. So if you have a concern, get a hold of your licensing board, their licensing board to express that concern. Now, malpractice lawsuit requires an attorney and it's going to cost you money, and there's more on that. But licensing boards don't give damages, insurance companies do, so I don't know about that. What I do know as a psychologist and kind of sitting there is that the now adult child is going to have substantial grounds because they're the ones that have been most directly injured by the child's psychological abuse, and damage to their family, damage to years of their child development. And potentially you can, talk about monetizing that or doing something, punitive damages. I don't know. But the child's going to have a stronger case. The parent has the case because it's spousal abuse, using the child as a weapon. So they've been injured by the negligent misdiagnosis of the professional. So let's talk about some of the grounds here. Professional grounds. Again, I'm not an attorney, so you're going to have to talk to an attorney about the legal stuff. But from a psychologist point of view, we have two legally obligating duties: duty of care and duty to protect. The duty of care establishes our general responsibilities. You become a patient of mine and I've got obligations. And then the duty to protect is a specific obligation to make sure everybody's safe. So here's from Wikipedia. In tort law, a duty of care is a legal obligation that is imposed on an individual requiring adherence to a standard of reasonable care to avoid careless acts that could foreseeably harm others and lead to claim in negligence. In the first element that must be established to proceed, it is the first element that must be established to proceed with an action in negligence. The claimant must be able to show that a duty of care imposed by law that the defendant has breached. In turn, breaching a duty may subject an individual to liability. So this first one establishes the duty of care. So that's for the treating psychologist for the child. That's clear. Okay, so they absolutely have duty of care. They may argue they don't have duty of care for the parent, but they do have duty of protect. So that's irrelevant. But yes, they do have duty of care if you're involved in any way in the treatment and that you're part of their patients. Kind of thing. And they should have signed an informed consent with you, and they should be doing all this stuff, but they're not. So you may also, in addition to the competence standards, there's informed consent that's often problematic over here. And disclosures as well. I've noticed that sometimes you get a little lax about disclosing private information about the parent to other people that shouldn't be disclosed. But those are administrative issues we'll talk about later. One of the issues you're going to run into is reasonable. That word, reasonable care, that's what I am. Dr. Childress is your standard of what a reasonable psychologist would do in this situation. Reasonable competence, reasonable actions, duty to protect, those sorts of things. So that's what I represent in the field. I represent your reasonable action. And then the prevent foreseeable harm. And notice the negligence part. So let's talk about negligence for a second. Let's stay on duty of care for one more quote here. This is from Davies and Shaw, and you can Google them and find it about duty of care. Physicians have a legal duty to provide a certain standard of skill and care to their existing patients. The legal duty of care is created when a physician agrees to treat a patient who has requested his or her services. In determining what that duty requires, physicians should consider whether the care they are providing is what a reasonable physician would provide under the circumstances. Specialists would need to exercise a higher degree of skill in their area of expertise. So the forensic psychologists in the family courts would be considered specialists in this pathology. So they have actually a higher degree of skill to meet, and that's going to be relevant to the competence standards. And again, I'm the reasonable psychologist and the competence standards relative to that. So the other duty that is mandatory, is legally obligating, is the duty to protect. In medical law and medical ethics, the duty to protect is the responsibility of a mental health professional to protect patients and others from foreseeable harm. For the parent, the failure in the duty to protect is from the spousal abuse using the child as a weapon. Okay, so that would be your kind of grounds they failed to protect you because of their negligent incompetence and malpractice. For the now adult child, I think that's even stronger because it's a failure to protect the child from psychological child abuse, which is going to have a prominent distortion to their life course. Their life was going to go one way if they had healthy relationships, and it's going a different way because of all the family conflict and destruction that took place because the mental health professional failed to protect them. So let's talk about negligence for a second. So Google negligence, and it's a failure to take proper care in doing something. So you'll hear me use the word proper a lot. Did they conduct a proper risk assessment for possible child abuse to the differential diagnoses for each parent? And no, they did not. And so from the Cornell Law School definition of negligence is that negligence is a failure to behave with the level of care that a reasonable person would have exercised under the same circumstances. Either a person's actions or omissions of actions can be found negligent. The omission of actions is considered negligent only when the person has a duty to act, such as a duty to help someone. So the duty in this case is a duty to protect, the duty to protect the child, the duty to protect the parent from spousal abuse. So they have two grounds for protection here, and they failed. That's the omission of a protective response that they were required to take. And as a result, that's negligence. They failed to show proper care. Dr. Childress, a reasonable psychologist, is telling them, do a proper risk assessment. They're not doing it. So, they don't care. They're not motivated to be competent. They're just apathetic and don't care. So with the licensing board complaint, so there's two levels. The first level, it's free, it's appropriate, it's what you should do if you're concerned about ethical standards or problematic practice, is contact the licensing board and tell them your concerns. Now, when you file a licensing board complaint, understand they're not going to retry the case. They're not going to look at the diagnosis and see if they did the right, diagnosis, or looked at the proper evidence, or looked at all the material you gave them and they didn't look at this, and they're not going to look at that. Right? That's not what the licensing board is going to spend their time doing. They just don't have the time to retry every case. What they're going to look at is what standards of practice were violated and what ethical violations. So they kind of go together: standards of practice, ethical violations. The ethical violations to raise, typically in all of these cases, are three: violation to standard 2.01, boundaries of competence. They don't have the necessary background in delusional thought disorders and child abuse and trauma and attachment pathology and factitious disorders and personality disorders. There's a variety of things. The strongest is on the delusional thought disorders. They do not have that expertise. Attachment is the second strongest. They do not have that. The standard 2.04 is the second violation. That's the basis of professional, scientific and professional judgments. Now, that is the application of the knowledge that they're supposed to know under 2.01. So typically, the entry into that is from their reports and things, and it's standard 2.04. They didn't apply any established knowledge, and so it's a violation of that. The reason they didn't apply knowledge is they didn't know the knowledge. That's 2.01. 2.01 is their vita, 2.04 is their report. Then because both of those, because they don't know the knowledge, 2.01, and did not apply the established knowledge, 2.04, then 9.01, their opinions, as in their reports, recommendations, diagnostic and evaluative statements, including their forensic testimony, are not based on information and techniques sufficient to substantiate their findings. Information 2.04, techniques, mental status exam. So those are your complaints package that is typically available to parents from all these forensic psychologists, because they are just simply don't care about violations to ethical standards or compliance with ethical standards for competence. Now, if you get sanctions for anything on that, then roll that into the malpractice lawsuit for the negligent failure and duty to protect. So if you go back and look in the board complaint, I have the ethics standards at the top, and then the negligent failure and duty to protect. With the malpractice lawsuit, it kind of flips. The negligent failure and duty to protect is your lead argument, and then the ethical violations support why there was that negligent failure. And if the ethical violations have been confirmed by the licensing board, then the malpractice insurance carrier is less likely to want to take this all the way through litigation, because the licensing board has already sanctioned the person. So now this is where we kind of land, or where I kind of land on the whole issue, is if the now adult child awakens to the nature of their psychological abuse by the involved therapist. I'm not talking about their psychological abuse by the parent. That's parent stuff, that's family stuff. And this is the failure of the involved therapist to protect them. Then the now adult child may have substantial grounds for malpractice if ethical violations were found by the licensing board. So that's another consideration for parents as you're going through. Typically, the pathological parent targets the oldest child when you have multiple children, and the youngest child can kind of sometimes slip a little bit through less affected, or there's variations in families of how kids. In addition, the now adult children can come into an awareness about what happened, was going on in childhood, and the failure of the mental health professional. They don't necessarily need a full understanding of that, just an appropriate understanding of, wait a minute, this wasn't right. What happened with this professional? And if there are board sanctions against the professional, then that now adult child has like good grounds to stand on. So for parents, you may want to proceed with other administrative actions relative to the involved professionals for their negligence and incompetence and various things, simply to provide any additional support that your children, when they get into young adulthood, may appreciate if they ever review their situation and what happened in their situation. And so that's a second component relative to, for parents to think about what you're doing on the situation. And given how vulnerable the mental health people are to their child client who grows up and comes back at them, if that happens, that therapist is going to be in a lot of trouble when their now adult child is saying they did stuff. And you can bring Dr. Childress in and do stuff, and that therapist is going to be in a lot of trouble when their child client reverses on them. One of the things to understand about the pathology is that these therapists are what's called the betrayer role in the trauma reenactment. And that's the person who should protect, but doesn't. Typically, that's the mom in the sex abuse thing where she sacrifices a daughter to the husband or stepdad to save her marriage. That's the betrayer role in sex abuse. Here, the betrayer role is being filled by the forensic psychologists, the ones who should protect and don't. And so we are activating them into their protective role, which is appropriate to their mental health license and status and things. We have duty to protect obligations. And here is the significant danger with this specific pathology, a shared delusion, not with anything else, not autism or anything, a shared delusion, this specific pathology, is if the mental health professional believes a shared delusion, then they become part of the shared delusion. They become part of the pathology. And when that pathology is the spousal psychological abuse of the targeted parent by the allied parent using the child as a weapon, the professional becomes part of the spousal abuse. The mental health professional is a spousal abuser working in the family courts and is abusing parents as part of their role, authorized role in the family courts. That's an abomination. As more importantly or more significantly is when the pathology is the psychological abuse of the child, the professional becomes part of the child abuse. So we have child abusers in the family courts working with these families, participating in the psychological abuse of the child, because they are practicing beyond the boundaries of their competence and they don't care. They are negligent, they are ignorant, they are incompetent, and they are unethical. And they don't care. And so that's the failure in their duty to protect. And I have obligations under 1.04 and 1.05 when I believe there's been an ethical violation by another psychologist. Yes, a group of psychologists are called forensic psychologists. 2.01, 2.04, 9.01. I've got obligations, 1.05. 1.05 says ethical boards, licensing boards are the appropriate response. So I'm informing you that licensing boards are an appropriate response to your concerns. And if the licensing boards finds anything, then move it into malpractice. And for the now adult children, or by children who are still children, once you get to majority, there's potential grounds for malpractice relative to the involved treatment that you received, the inadequate and abusive range treatment, because they were supposed to protect you. They were supposed to see you're the kid. You're a child. You're caught up with parents and parental influences and loyalty stuff going on in the family. It's very chaotic. It's not for you to understand what's going on and do. It was their responsibility, the mental health person that was involved, to see what was going on and to take the proper steps to protect you. And they didn't. Okay. And that's a problem. And so while the parents and everybody's fighting on that, you, the kid from Dr. Childress, they had obligations to you and they failed. And so our goal eventually is that we will have no trauma survivors out of the family courts. Right now, we got lots. We got kids that are surviving the family court trauma and parents that are traumatized in the family court. We should have zero. We should be fixing it and solving it. Zero kids should be coming out with destroyed lives. Zero parents should be coming out with destroyed families. And so forensic psychology is a failed experiment in service delivery to a vulnerable population. It needs to end. Clinical psychology needs to come back. We're in a transitional phase because of the collapse of forensic psychology, and we are establishing baseline ground foundations for competence. And that's the APA Ethics Code. That's our baseline, at least at the level of the APA Ethics Code, and then we move higher from that. So with that, I'm going to head off to my Sunday here, going to a baseball game, and yay, go Mariners. And we'll talk to you about some aspect of the family courts next week. So with that, take care, everybody, and enjoy your Sunday.